Yes.
Mr. Matson, don't interrupt me, please.
Mr.
Mr. Matson, do not interrupt me, please.
I think the court is making a big mistake here.
Mr. Matson,
I've never signed anything to
Mr. Matson, if you don't stop talking, I'm going to your device.
Well, I didn't want
Mr. Matson,
Daly
stop
as my
talking.
attorney. I'm a living flesh and blood man. They're trying to sentence an all caps name. It's not me. I'm a living flesh and blood man. You're after a fictional person. The only one I've ever taken an oath to is God Almighty Himself. There's only one lawgiver, one creator, one judge. That's God Almighty. That's who I recognize.
And sir, you are Robert Joseph Matson, correct?
So, I'm a living flesh and blood man, attorney for a public officer or statutory citizen judge. I'm a living flesh and blood man.
All right. You are the living flesh and blood man who's known as Robert Matson, correct?
Attorney for Robert Joseph Matson, which would be the all caps name. Judge, there was something that I was trying to talk to my attorney about. Before you let me out of the hospital, I was in the hospital or the jail. I was experiencing a lot of pain and trouble. The jail was not treating me properly. After I got out of the jail, I went to the hospital, and they hurried and rushed me to Toledo Hospital, where I almost died. Had I not been released from jail when I did, I would be dead in that county jail.
All right, Mr. Matson, we're here for your sentencing hearing today. I'm not really able to address issues of medical treatment while at the jail.
Well, I was just saying that there was something I agreed to.
Mr. Matson, don't interrupt me, please. The medical treatment that people receive at the jail is not within my purview, and I'm not going to address that today. So,
well, I just saying I was going to correct my.
Mr. Matson, do not interrupt me, please. Have you had an opportunity to read and review your pre-sentence report?
I did with the secretary for Mr. Daly.
Have you had an opportunity to discuss your pre-sentence report with Mr. Daly?
I haven't had an opportunity to discuss it with him. I did with the secretary.
My secretary got a hold of him.
Mr. Daly, if you could just let me allow him to finish his answer. What were you saying, Mr. Matson?
I did with the secretary.
Welcome back to another jaw-dropping courtroom showdown. And this one's wild from the very first second. Meet Robert Matson, a self-proclaimed living flesh and blood man who believes the legal system can't touch him because, in his words, they're after a fictional all-caps name. That's right. He's diving headfirst into the world of sovereign citizen logic, where paperwork and wordplay supposedly trump criminal charges. But here's the twist. This isn't some YouTube skit or protest. This is real court, and a real judge is just about enough. Today, we'll watch as this defendant challenges the court's authority, interrupts repeatedly, and spins into bizarre legal theories, all while the judge keeps her composure like an absolute pro.
I appreciate that, Mr. Matson, and we've discussed it.
Any of my rights or immunities. I'm not a statutory citizen. I am sovereign. I'm not somebody who's under the
Mr. Matson,
I've never signed anything to
Mr. Matson, if you don't stop talking, I'm going to your device. Okay? I've discussed all of these issues with you before.
Okay.
And
well, I object, but I mean,
Mr. Matson,
this is your
all
duty.
right. I've muted Mr. Matson's device because he won't stop interrupting me. Mr. Matson, what I'm trying to tell you is that we have discussed these issues before. You've raised those issues. I've ruled against those issues. And ultimately, you pled guilty of your own choice to the controlled substance, possession of narcotic less than 25 grams. And so I'm going to sentence you on that charge today. If you'd like, I will have Mr. Daly step into the hall and you can have a breakout session with him so you can speak with him about your pre-sentence investigation report if you have questions or things that you want to talk with him about regarding that report. So I'm going to unmute your device now, and I want you to tell me whether you want a breakout session with Mr. Daly or not.
Hello?
Yes, we can hear you now. Do you want a breakout session with Mr. Daly?
Well, I've tried to talk to Mr. Daly before, about
Manson,
this.
Answer my question. Do you
Yes,
want
sir.
a breakout session with Mr. Daly or not?
Your Honor, you're going to do what you're going to do. I mean, I've tried to talk to the courts and reason with the courts. I mean, if you're going to sentence me today, then I just file for an appeal. I'm an objection to anything that happens today. I was under duress when I took the plea due to my life was at stake.
Mr. Mattson, please answer my question. Do you want a breakout session with Mr. Daly or not?
Mr. Daly hasn't been much of help for me, Your Honor. So I mean,
that is not an answer to my question, Mr. Mattson. Please answer the question. You want a breakout session with him or not?
Sorry, Your Honor. It just ain't been doing me any help, no justice at all. I mean, I've already said what I had to say. If the courts is going to sentence me today, then that's what they're going to do. I don't agree with anything that's going on today. I'm sorry. My life was at stake when I had talked to the courts.
All right, Mr. Mattson, please stop talking. So you refuse to answer my question about whether you want a breakout session with Mr. Daly or not. The law.
I didn't want
Mr.
Mr. Daly as my attorney.
This is a classic opening line from the Sovereign Citizen playbook, rejecting man-made laws in favor of divine authority. But here's the thing. Courts don't run on belief systems. They run on statutes and evidence. When Mattson says he's only accountable to God, it's not spiritual devotion. It's a legal strategy that never works. Judges have heard this argument countless times, and it always leads to the same outcome. More interruptions, more frustration, and zero progress. Notice the judge's tone, calm but firm. She's been here before and knows exactly what's coming next.
Just had a repeated conversation you already had. I'm prepared for sentencing.
All right, Mr. Mattson, you've now had an opportunity to discuss the pre-sentence report with Mr. Daly. Is that correct?
No, he didn't want to hear me, Your Honor. He just told me that he was here to get me sentenced. I tried to talk to him about things. I tried to talk to him before we even went to court about things that was going on with my life and me about dying, and as far as being incarcerated in jail, which he didn't ever try to help me out, because if he would have did an investigation and known that I was in court and I was wrongfully put in jail. I told him I'm not a statutory citizen. I'm a constitutional citizen. I mean, he don't care to do anything to help me. All he cares about is just helping you guys out and get me sucked into the system, and it's wrong.
All right. For the record, I did provide Mr. Mattson with an opportunity with Mr. Daly in a breakout session. Mr. Mattson.
Yes, sir.
Satisfied with Mr. Daly and the advice that he's given you?
I'm not satisfied with the advice he's giving me. No, sir.
Do you wish to explain or challenge the accuracy or the relevancy of any of the information that's in your pre-sentence report?
The stuff that's in the pre-sentence report is directed to a statutory citizen. I'm not a statutory citizen. I'm a constitutional citizen. You cannot be a constitutional person and a statutory person at the same time, Your Honor. You have to be constitutional rights, which the court's designed to protect rights. So I was asking you, Judge, are you working as a banker or a judge today? I mean, there's nothing.
Now Mattson shifts gears. Suddenly, it's not about sovereignty. It's about suffering. This move is strategic. When one argument fails, he pivots to emotional appeal. He brings up pain, hospitals, and near-death experiences. But notice how none of that addresses the charge. The judge makes it crystal clear that medical grievances aren't relevant to sentencing. Yet Mattson keeps talking. This is courtroom theater at its peak. Dramatic, emotional, and totally off topic.
Arguing the basis of your conviction, again, you pled guilty to this charge. What I'm asking you is, but Mr. Mattson, what I'm asking you is whether you'd wish to explain or challenge the accuracy or the relevancy of any of the information that is in your pre-sentence report. So is any of that information inaccurate?
Inaccurate as far as the person that reports they're trying to sentence in all caps names. It's not me. I'm a living flesh and blood man. You're after a fictional person.
All right. So with respect to that argument, what the court will say is that I will leave the information that is in the pre-sentence report in the pre-sentence report and deny what seems to be some kind of a request to modify the pre-sentence report based on an argument that doesn't state any cognizable legal theory about a difference between Mr. Mattson as a human being and Mr. Mattson as something else. So the pre-sentence report will stand.
Well, Your Honor, you never even explained to me what the jurisdiction was. I tried from the beginning that
Mr.
the
Mattson,
jurisdiction
all
of
right.
the court is.
I'm going to mute Mr. Mattson again because he continues to interrupt me with a line of argument that I don't even know what to say about it. It just is, it's not a legal argument at all. It is some kind of fanciful belief that there's a difference between Mr. Mattson, the human being, and Mr. Mattson as some other entity, which is not recognized by the law, and I'm not going to entertain it any further. The probation officers calculated the minimum sentencing guidelines in this case to be from 0 to 9 months. Do you agree with that computation of guidelines,
Your
Mr.
Honor.
David? Sorry,
I do.
Thank you.
Boom, the mute button. It's the modern courtroom version of the gavel slam. When a defendant won't stop interrupting, the judge has every right to regain control. What's impressive here is the professionalism. She doesn't yell, doesn't threaten. She simply silences him and proceeds by the book. That's what separates a skilled judge from chaos. Mattson's still trying to challenge authority, but the courtroom dynamic is clear. The judge runs the show.
Mr. Mattson, in a moment, I'm going to unmute your microphone, and I'm going to give you an opportunity for allocution. That's an opportunity to say anything that you'd like to say on your own behalf before the court passes sentence.
Yes, sir. Can you hear me?
Is there anything you'd like to say on your own behalf?
You said that. I can say anything that I wish before sentencing.
You can.
I'm sorry, sir.
You can.
Okay. Yes, sir. Your Honor, I mean, before I took that plea, I told Mr. Daly that I wanted to sit there. I wanted him to sit there, get the cameras for the courts to prove that I was at the court date the day that I was put in jail, and said that I wasn't in the court for a contempt of court. He said, and I told him I wanted to fight my case, but I had to be out because I had medical issues. Mr. Daly said that's fine and all, but if you stay here and you fight this case, they'll keep you in here for a year fighting your case. You will not be let out of jail. Your Honor, I couldn't do that. I was in major pain. I would have died in that jail. My proof is within the doctor's records in the hospital. I had a serious condition which would have left me dead within a week from the time that I took the plea. The following day after I got up, my wife was killed in a car accident. Because everything's been going downhill for me ever since. And now this with the courts. I don't feel that I've had a fair chance with the courts ever since I even started with the court, because the courts has not proven jurisdiction to me. I've not written any papers out agreeing in the contract saying that the courts can have any kind of jurisdiction over me. I have not relinquished any sovereign immunities that I have. I just don't feel like there's been anything fair, which is not going to be with the court system. I mean, I've tried to say I'm not a statutory person who is within your jurisdiction. If anything, I'd be considered constitutional, but I'm not even under the constitutional laws, but I will use them if I feel necessary as a constitutional living flesh and blood man.
Let's break down what's really happening here. Mattson isn't just arguing. He's rejecting the very foundation of government law. He believes he exists outside of it because he never consented to the system. IT sounds absurd, but thousands of sovereign citizen cases start exactly like this. The problem? Courts don't operate on consent. They operate on jurisdiction. And jurisdiction isn't optional. The judge's patience here deserves an award. Even as Mattson keeps looping his flesh and blood man speech, She continues methodically, showing the audience what true judicial restraint looks like.
You can't be a constitutional person and a statutory person at the same time. Either you're one or the other. And Wi-Fi wasn't working properly on my computer. I couldn't draw up my own paperwork. I've been in nothing but severe pain. I've been able to move around and do much of anything for myself. The only one I've ever taken an oath to is God Almighty himself. There's only one lawgiver, one creator, one judge. That's God Almighty. That's who I recognize. For me to sit there and agree to anything more than that would be me sitting there violating the laws of my God.
All right. In determining the appropriate sentence in this case, the court has considered the seriousness of your offense, your history, the principle of proportionality, the statutory penalty, the cost of confinement, the report and recommendation of the probation department, as well as what's been said on the record here this morning. The criteria and reasons for the sentence are the nature and gravity of the offense, the discipline appropriate to its commission, deterrence against repetition by you and by others, vindication for the law, and the protection of society. As indicated, with respect to these sovereign citizen or whatever the other arguments you're making are, we've dealt with the jurisdiction issue in the past. I've ruled on that on at least one occasion, probably multiple occasions, and that ruling is not going to change. You will have appellate rights if you want to pursue those. You're welcome to do that, but you have pled guilty.
And here comes the infamous twist. The banker-judge claim. This stems from a bizarre internet theory that courts are actually corporations trading people as financial assets. It's total nonsense, but for people like Mattson, it feels empowering. What's fascinating is how confidently he says it, like he's uncovering a secret truth. But this confidence is exactly what traps him. The more he argues his fantasy, the further he drifts from reality, and the closer he gets to a harsh sentence.
Back with us now. Mr. Mattson, we are in a court proceeding right now, and so I'm going to ask you not to eat anything and to remove your hood. All right, I'm going to ask you to remove your hood also, Mr. Mattson. Thank you. Mr. Mattson pled guilty to one count of controlled substance, attempted possession of cocaine, heroin, or another narcotic of less than 25 grams, pursuant to a plea agreement which dismissed one count of possession of cocaine, heroin, or another narcotic, dismissed one count of driving the license suspended, and one count of alcohol open container. So the agreement was to one count of attempted possession of a controlled substance, dismissal of the remaining charges, and that was apparently incorrect. There was no sentencing agreement in this case. This is Mr. Mattson's first felony conviction. He does have 4 prior misdemeanors. Those are all from 2015 or earlier. He has 2 2015 cases and a 2002 and a 2001. And so the recommendation in this case from the probation officer is for a period of 1 year probation. And I think that, well, it also, I should say, includes restrictions on alcoholic beverages and substance use. And I think that those provisions of terms of probation are appropriate given Mr. Mattson's Compass Needs Assessment scores. He did rate as highly probable in the categories of substance abuse, family criminality, residential instability, and social environment. He does have a substance abuse history of cocaine, fentanyl, painkillers since 2005. I think that it is appropriate to try to get Mr. Mattson some help for his substance abuse problems.
That's the line, the moment when the judge officially shuts the door on nonsense. Not a legal argument at all. It's professional code for enough is enough. After nearly 15 minutes of interruptions, the court finally clarifies that no, there's no magical divide between the man and the fictional entity. The law recognizes you as one person, period. This moment is crucial because it shows how courts handle pseudo-legal chaos, not with anger, but with clarity and record-keeping. Every ruling, every mute, every explanation builds a paper trail that keeps this process airtight.
I don't know where it comes from, but I will say Mr. Mattson would be far better off taking legal advice from Mr. Daly than from wherever it is that you're getting it to make you believe these arguments, because as I've ruled repeatedly, there's just no merit to them. They're not rational or coherent arguments under the law. And the concern that raises with me is that Mr. Mattson, if he does not believe this court has jurisdiction, why then would he follow the terms of his probation? And so if that's the question, then the question I have to ask myself is why would I put him on probation if there doesn't seem to be any indication that he would follow the terms of the probation? The other side of that coin is that I think a lot of this stems from Mr. Mattson's substance abuse issues, and the better way to get him help for his substance abuse issues is to put him on probation and get him into some kind of services to help him deal with that. So ultimately, Mr. Mattson, I'm going to give you a chance at probation. I hope that you are willing to comply with the requirements that are outlined in terms of your probation, which I'll read to you word for word in a moment so that you're aware of them. If you choose not to comply for the reasons you've stated or any other reasons, you can rest assured you're going to find yourself in violation of the terms of your probation. And then I am going to be imposing other penalties, meaning for you jail time. And I'll just tell you now, it'll be a short leash, because if we continue down this road, I'm already suspect of your ability to comply. So any violations are just going to confirm that for me, and you're going to find that I'm going to lose my willingness to give you a chance. So it will be the sentence of the court that you serve a period of probation for 1 year, that you serve 29 days in the Lenawee County Jail with credit for 29 days served. You must not use or possess alcoholic beverages or other intoxicants. You must not enter bars or other places where the primary purpose is to serve alcoholic beverages for drinking on site, unless the field agent has first given you written permission for your employment at a specific location. You must comply with the requirements of drug and alcohol testing as directed by the field agent. You must not attempt to submit any fraudulent or adulterated samples for testing. You must not hinder, obstruct, tamper, or otherwise interfere with the testing procedures. And you must present proper identification at the time of testing. You must pay the cost of your substance abuse testing. You must not be in possession. You must not use or possess any controlled substances or drug paraphernalia unless prescribed to you by a licensed physician.
And there you have it. Another sovereign citizen case collapsing under the weight of its own confusion. From claiming divine authority to accusing judges of being bankers, Mattson tried every tactic to dodge accountability. But in the end, the law stands firm. This judge showed incredible patience and professionalism, handling chaos with calm precision. It's a perfect example how logic always outlasts delusion in a courtroom. If you found this case as shocking as we did, hit that like button, drop your thoughts in the comments, and subscribe for more real courtroom breakdowns where justice, logic, and chaos collide.